A suspect sat in an interrogation room and said nothing for 2 hours and 45 minutes. Not a word. Then he answered one question. One word. Yes. And just like that, the Supreme Court ruled he had waived his Fifth Amendment rights. That single syllable put him in prison for life. I'm Patrick. I'm an attorney, and here's what I tell every client before they ever talk to the police. First, don't do it. Second, your right to remain silent doesn't work the way you think it does. Silence alone is not enough. You actually have to say specific words out loud now, or you lose the protection entirely. Today I'm going to give you the exact strips criminal defense lawyers use, the Supreme Court cases that created these rules, and a decision framework so you know exactly what to do, whether you're at a traffic stop, at your front door, or sitting in an interrogation room. Let's start with what the Fifth Amendment actually says, and more importantly, what it doesn't say. The text reads, "No person shall be compelled in any criminal case to be a witness against himself." That's it. Notice what's missing? It does not say you have a right to remain silent. That phrase comes from Miranda warnings and case law, which are procedural requirements, not the amendment itself. And here's why that distinction matters. Miranda only applies during custodial interrogations. That means you're in custody and the police are asking questions designed to get incriminating answers. A traffic stop is generally not custodial. Cops knocking on your door? Yeah, that's actually not custodial. A voluntary interview at the police station. It's not custodial until it is. Now, outside of a custodial interrogation, the Fifth Amendment protection is a lot weaker. Courts in some jurisdictions will let prosecutors point to your silence before arrest and tell a jury, notice how the defendant didn't deny it. That should absolutely terrify you. Let me walk you through the case that changed everything. Berghuis v. Tompkins, 2010. Vanchester Tompkins was a suspect in a shooting. Police read him his Miranda rights and he didn't sign the waiver. He didn't say that he understood. He just sat there. 2 hours and 45 minutes. He said almost nothing. He'd given a few one-word responses, yeah, no, a head nod, but mostly just silence. Then a detective asked him, do you pray to God to forgive you for shooting that boy? Tompkins looked away, tears in his eyes, and said yes. That single word became the centerpiece of the prosecution's case. His lawyers argued that he'd invoked his right to remain silent by, actually being silent. And the Supreme Court disagreed. 5-4 decision, Justice Kennedy, writing from the majority, said Tompkins never unambiguously invoked his right. His silence is not an invocation. And that by answering that single question, he implicitly waived his right to remain silent. Let me say that again. It is that important. After nearly 3 hours of silence under questioning, it meant nothing because he never said, I invoke my Fifth Amendment right to remain silent. The court essentially created a rule that you must invoke your right, silence. It's counterintuitive. You have to speak to be silent. It's arguably absurd, but it's the law. And it gets worse. Salinas v. Texas in 2013. Mr. Salinas wasn't even in custody. He voluntarily went to the police station and answered questions for an hour. Here's an aside. Do not do that. Ever. He was cooperating. He was being helpful. Then the officer asked whether shotgun shells found at the crime scene would match his gun. And Salinas stopped talking. He shuffled his feet. He bit his lip. He went quiet. He didn't say, I'm invoking my Fifth Amendment right. He just clammed up on that one question. At trial, the prosecutor told the jury, and I'm paraphrasing here, wow. Just look at his reaction when he asked about the shells. He went silent. That's the behavior of a guilty man. Salinas' lawyers took it all the way to the Supreme Court, arguing that using his silence against him violated the Fifth Amendment. The court said no, because Salinas was there voluntarily, because he was not in custody, and because he'd never explicitly invoked the Fifth Amendment. Prosecutors could absolutely use his selective silence as evidence of guilt. This is the trap. You can cooperate for an hour and then go quiet on one question, and that silence becomes a weapon against you. All right, so now you understand the problem. Let me give you the solution. These are the exact invocation scripts that I walk clients through. And I'm going to put them on screen in a format you can screenshot. Save these to your phone. Scenario number 1. You're pulled over at a traffic stop. The officer walks up and says, "Do you know why I pulled you over?" The wrong answer is anything that admits fault. "I was going a little too fast" is a confession. "I think my taillight is out" is a confession. Don't guess, don't explain, don't apologize. Here's what you say. "I'm not answering questions, but here's my license, registration, and proof of insurance." You comply with the document request. Those are legally required. But you don't answer investigative questions. You're polite. You're not hostile. You just don't talk. Scenario 2. Police knock on your door. They want to ask you about something that happened in the neighborhood. Maybe something involving you. You step outside. First, don't step outside. That's a separate subject. Don't let them in your house. And you say, "I'm not going to answer questions without my attorney present. Am I free to go or am I being detained?" That question forces them to clarify your status. If you are free to go inside, close the door. If you're being detained, you've already invoked. Scenario 3. This is a big one. You have been arrested. The moment you realize you're in custody, whether they put cuffs on you or they just told you you're not free to leave, say this exactly. "I am invoking my 5th and 6th Amendment rights. I will not answer questions or make any statements without my attorney present." Then stop talking completely. Don't chat with officers on the ride to the station. Don't explain yourself to the booking clerk. Don't make small talk with other people in your cell. Don't discuss your case with anybody in the holding cell. Some of them might be informants. Hell, all of them might be informants, and some of them are actively trying to send you to prison. Don't make phone calls discussing your case on the jail phones. They are all recorded. Those recordings are reviewed, and they will be used. Okay, the 5th Amendment is your right against self-incrimination. The 6th Amendment is your right to counsel. You invoke both because together they create the strongest legal shield available to you. Once you say those words, the police are legally required to stop interrogating you. If they don't, anything they get is likely going to be inadmissible. Okay, but, and here's the Berghuis lesson, if you sit there silently without saying those words, they can keep going for hours. And we have cases and case law that shows that police have interrogated people for 15, 17 hours nonstop. Okay? You have to invoke your rights. Now, some of you are thinking, "But Patrick, I'm innocent. I don't have anything to hide. Why wouldn't I just explain what happened and clear my name?" Well, here's why. And this isn't just my opinion. There's game theory analysis. It's been published in the Yale Law Journal that breaks this down mathematically. Okay, remaining silent protects innocent people more than it protects guilty people. It's counterintuitive, so let me explain that. When innocent people talk to the police during high-stress interrogations or situations, they make mistakes. When innocent people are trying to remember something, they misremember times. They give inconsistent details. Not because they're lying, but because human memory under stress is unreliable. They'll say something that contradicts another witness. Now there's a discrepancy that prosecutors can exploit. They nervously fill silence with speculation. Guilty suspects, ironically, often have rehearsed stories ready. They've thought about what they're going to say. Innocent people haven't, because they didn't think they needed to. Okay? And here's the other thing. Lawyers know what civilians don't. Nothing you say to the police can be used to help you in court. It's not an exaggeration, it's hearsay. If your attorney attempts to introduce your own exculpatory statements, it's not coming in. Only the incriminating statements come in. The game is rigged, and the only winning move there is to not play. So let me put this all together with the decision framework for you. When you encounter the police in any situation, you need to answer 2 questions. First, am I in custody? If you've been arrested, told you can't leave, or a reasonable person in your situation wouldn't feel free to leave, you're in custody. Invoke the full 5th, 6th Amendment script immediately. Question 2. If you are not in custody, are the police asking investigative questions? If they're asking for your name during a lawful stop, many states require you to identify yourself. Okay? If they're asking you for documents during a traffic stop, provide them. If they're fishing, do you know why I pulled you over? Where are you coming from? Do you know anything about what happened here? Those are investigative questions. You decline to answer and ask if you are free to leave. A key principle across every scenario is this: comply with lawful orders. Provide legally required documents. Never answer investigative questions without an attorney. And always invoke explicitly, out loud, using the words. And as a brief aside, if you hire an attorney that says, hey, go talk to the cops, shop for another attorney before you do something stupid. So let me leave you with the contrast that should stick in your head. Person A gets arrested, says nothing, sits there quietly, thinking that they're exercising their rights. The police interrogate over an hour. At the end of the trial, the prosecution argues, successfully, after Berghuis, that this person never invoked their right and their silence means nothing legally. Person B gets arrested, immediately says, I invoke my 5th, 6th Amendment rights. I want my attorney. I will not answer questions. The interrogation stops. Anything obtained after that statement is likely thrown out. The same silence, same intent, completely different legal outcomes. The only difference is 11 words that were spoken out loud. Here's what I need you to do right now. Screenshot those invocation scripts. Save them to your phone. Put them in your notes app, your favorites, wherever you'll find them under pressure. Then you send this video to one person in your family who doesn't know this. Because the moment you need these words is the worst possible time to be learning them for the first time. If this is useful to you, subscribe. I break down legal concepts like this every week in plain English so that you are never caught off guard. I will see you in the next one. Thank you.